This meeting is being recorded.
Okay, so I've got a little feedback from somebody here, Shar. I'm going to mute you out here for a minute. I've got one more person jumping on board here. So just a little bit after 3. So I want to welcome everybody to December the 13th, 2024 in Family Forward Project Training 10. So as I have told you before, I kind of just go through my mind. I'm watching everything that people are talking about through the groups online, etc., as well as just my experience over the years. And these topics, I'm trying to pick out like what's the chatter, what are people trying to ask about from the legal perspective, of course, because I am not a psychologist or mental health professional. So for right now, I'm focusing on just those legal aspects of it. And filing complaints is one big part of that. So before we begin, I am going to talk just a minute about schedule. So this is December the 13th. This is training 10. I think next week, although I was going to do next week, December the 20th, I think it's just a little bit too close to the holidays. So we're going to bump out and just let everybody enjoy the holidays with no Connie stress on them for a couple of weeks. I don't think I will come in on January, the first week of January. I actually have a root canal scheduled that week, so I'm probably not going to be in very good form. But definitely by January the 10th. On January the 17th, I will be in Washington, D.C. I'm not sure. I may do a just training from DC, giving y'all an update of what we've done because we will have been there for 5 days. Or we may do a special one. That would be a good week to do one specifically on the Family Advocates for Families Act. Then my plan is to go ahead and do through the remaining Fridays in January and through February the 28th. That will give us, if we are successful every week, that will give us 18 hours of training. So again, if there's any particular topics, I will tell you I am going to work on ADA, Americans with Disabilities Act. Chad's been doing a lot of research on that. He's going to share with me. We will be doing civil rights litigation, which is always sort of a trap in a way. And then, we may talk more about permanency plans. I am getting a lot of complaints from parents that they are doing what the state tells them to do, and they are not returning their children, that they're going through everything. People are refusing to turn in paperwork, refusing to account for it, etc. So that may be a topic. And then I have a few other things in my mind as far as the civil procedure part of it, like what are motions to intervene, how to work more specifically with experts, etc. So today is filing complaints. There are only, I believe, about 24 slides on this, so a little bit fewer slides, but we're going to kind of do the garden variety and slip through what are the sort of complaints that go through our mind when we're in CPS litigation and our parents want to know about and advocates should know. So we're going to, do a preliminary on judges, guardian ad litems, attorneys, federal complaints, civil rights, and claims commissions. So first, let's talk about the judge. So when a lot of people have problems with their judges, it's such an obstacle in, oops, somebody else trying to jump in here, such an obstacle in CPS litigation. We're dealing with family court and juvenile court judges. There's a lot of, debate as to whether or not they follow the law, who they appoint, what their fraternities are, etc. But when you step in the courtroom, these are some of the things that a litigant should expect. They should expect a judge to be unbiased. There should be no outside influences, no fraternizing, and no conflicts of interest. As we talk about complaints, I want people to think about, like, in the process, this should be one of the first videos that parents and advocates look at so that during that process, they can start making notes right away of the observations that they see. The judge should be knowledgeable of the law and the constitutional rights of litigants. They should respect those in the courtroom. They should have timely adjudications. There should be no ex parte communication. There should be timely rulings. There should be, they should allow access to the court process. A lot of parents say, they won't let me talk, they wouldn't let me be heard, they wouldn't accept my documents, etc. They should implement due process, and due process means basically notice and the right to be heard. That is what constitutes due process. And then they shouldn't be sexting or soliciting favors from litigants and attorneys. Now, that sounds pretty bizarre. Of course, I know, but believe it or not, of course, we have caught judges doing that, and especially playing with their phones, and God knows who they're texting and what they're doing on their phones. Each state has their own ethical code for judges. So in Tennessee, it's Supreme Court Rule 10, and most states have a statutory code for discipline, which includes a few more grounds for disqualification. So in Tennessee, that's a code section 175201. And you'll remember from our last training, we talked about the differences between rules and laws. So the Supreme Court rule is a rule. Now, Supreme Court rules are supposed to be approved by the Tennessee General Assembly. Some are not, amazingly. And then, of course, the code section is passed by the General Assembly. So for your state, wherever you are, if you're in Kansas, Kentucky, Illinois, Michigan, you should be able to Google ethical code for judges for Kentucky, or put the state first. Kentucky ethical code for judges, Kentucky judicial discipline, etc. And that's how you're going to find it. All right, so in judges, some of the grounds for complaint to disciplinary boards may be obvious conflicts, rudeness, cutting off litigants, failure to follow the law, constitutional violations, and favoritism. And again, this is why it's so important that parents are documenting everything that happens in court. We've got to become better documenters. And I know, especially at the beginning of the process, so many parents trust and believe that people are going to do the right thing, right? They don't even think that they're going to have to hold them accountable because they're going to do their job. And they're going to do it appropriately and ethically. And unfortunately, we find out from the very beginning, and there are typically certain nuances, certain behaviors, characteristics that we notice from the very beginning. It can be something a judge says to a litigant. It can be being too familiar with an attorney in the courtroom. It can be having, sidebar conversations with a deputy or a clerk, or side comments. Every one of those from the very beginning should be documented. And of course, whenever we can, record or obtaining the recordings from the courtroom. So where to file? You file with the state disciplinary board for judges. What to file? There typically are complaint forms. I know for the state of Tennessee, I generated my own complaint form, and I think what Family Forward Project should do, I think that we should generate perhaps a JOT form, complaint form that we can help people submit. I think that needs to be one of our goals, where they can also upload their supporting documentation, identify witnesses, audios, etc. And then what to expect, I just say keep your expectations low, but be persistent in all communication. So as we develop as a stronger collaboration to really help move the goalpost on this, is, what kind of tools can we provide? I started in my WordPress pages like Family Forward Michigan, Family Forward Wisconsin, whatever. I started putting certain links in there. That is something that, I could probably get some help with, and we could just post pages on every state that would have the direct links to policies, laws, judicial complaints, judicial ethical code, etc. So I started it. 50 states is a lot, so it takes a lot of work. So maybe we can get a form, and y'all can pick certain states and help with that as well. So, with judges, I have seen some judges sanctioned. Very difficult to get to that point where they will sanction them. So, I just say, just kind of keep your expectations low, but continue to be persistent. I had one judge that had quite obviously ex parte communication. I filed complaints on it. And, they probably talk to the judge, but a lot of times they'll try to quash it before the judge even has to respond. Okay, so the state judicial disciplinary boards are notoriously lame in holding the judiciary accountable. They just are, but we've got to document it and we've got to put it out there because exposure is all we've got. We've got our voices, we've got exposure, we've got, putting it out there, asking people to hold others accountable, and then being able to state clearly that there is no accountability because we can't get more structure and more strict laws for accountability if we can't show, look, this is why you need it. Impeachment and removal. So this is a little bit different section that is applicable to judges. So every state has a constitutional provision for impeachment. In Tennessee, it's Article 5. Every state's going to have an impeachment clause. Typically, impeachment, like most of us these days, we know about impeachment in Congress, right? One house puts the impeachment together, and then the Senate tries the impeachment. And it's the same thing basically in a state court. So you have the House of Representatives, they put together a petition for impeachment, they put together probable cause, they have an investigation, they get all their documentation together, and then they sign an impeachment, which is basically in common language like an indictment. And then that is delivered to the Senate where they do the trial for it. And some states have I'm going to mute somebody here. Some states have a removal provision. So Tennessee has a removal provision, which is for direct removal by a state legislative branch with 2/3 vote. Not every state has this, but it's very important. We've only used it once or twice in the whole of Tennessee history, but it definitely is out there. And when I started lobbying back in 2008, I started educating all of our legislators on this removal provision. They didn't even know it existed. So these are just other things that we need to investigate, and we need to find out ways to use these tools that we have. So what are the duties of the guardian ad litem? So technically, they are supposed to interview the child, interview the parents with counsel. Parents should not be interviewed with either without counsel or without some type of recording, without some caveats that, guardian ad litems are notoriously hostile to parents. So they want to I'll use a lot of caution. They need to understand the child's risk, but likewise, they need to understand the child's preference. Now, they are required under law to advocate for the best interest of the child, which is incredibly subjective, right? Nobody knows what the best interest of the child is, even though there are statutory things to consider in a divorce. There are no statutory considerations for a guardian ad litem. If the guardian ad litem's perception of best interest differs from the child, they have a duty to inform the court so that they will appoint what is called an attorney ad litem, or some courts call it a preference attorney. They have a duty to be proactive for the child and not to just sit back and let everything happen around them. And they have a duty to protect the child from abusive placements. In most states, the guardian ad litems are licensed attorneys. Some states have lay guardians. I think Florida has a lay guardian program. I'm not for sure. But in addition to the ethical rules for attorneys, guardian ad litems have obligations that are defined either by statute or court rules. And in Tennessee, we have a Tennessee Supreme Court Rule 40, which kind of outlines what a guardian ad litem is supposed to do. So the guardian ad litem, the grounds for the complaint to the disciplinary board, if they failure to talk to children, failure to disclose to the court conflicts with the case or with the child's wishes, and showing bias towards an agency, I think are all grounds for filing discipline, as well as the other attorney grounds that we'll talk about here in a minute. So failure to talk to children, it's amazing how many guardian ad litems are not talking to the children or are not keeping in touch with the children during the course of the proceeding. They will go, I've had them go months before they even have an initial conversation with the child. And then they will wait months and months and months before they ever even follow up. They don't even get the DCS records. They don't even know what's happening. So where to file? Typically, that would be filed with an attorney disciplinary board. And what to file? Again, a written complaint. There are online forms now in most states where they can just go online. And then you can also upload documents, witnesses, audios. In other words, when a complaint is put together, it needs to be prepared. It needs to be prepared so that the reviewing board can at least make probable cause out of the items that are in front of it. If there's a transcript, an audio, etc. And what to expect, you're going to be really sad, I know, but again, expectations, we keep expectations fairly low, but we save all communications and be persistent. Sometimes the best we can do is get a guardian ad litem removed from a case or have a guardian ad litem decide to get out of a case just because they don't want the hassle of having to deal with parents who are going to complain against them. Now, the duties and responsibilities of attorneys. Yeah. Oh, look here. I forgot to do part of my training. Sorry about that over there. I was trying to get this ready in a hurry. So is to talk to the client, be knowledgeable about the law, protect the client's confidences, don't gossip, don't have secret meetings, secret communication, be proactive, protect the client from abuses by the agency, collect discovery from the client and the state agency, collect discovery from the guardian ad litem, prevent and stop secret reports from being filed, and make sure the client gets a copy of all documents, emails, and notice of all meetings, pleadings, court appearances, etc. Now, what I would have typed there on the other side is that the ethical guidelines for attorneys are also found typically in a Supreme Court rule or some rule of the court. In Tennessee, it is Supreme Court Rule 8. And before I upload this to Classroom, I'll go back and fix that and correct that so you actually have it on the slides that are in the classroom. Now, these expectations are surprisingly often not met, okay? Often, these are the simplest ones. These are the most basic. Talk to the client. Recently, a mom called me. She had had several court-appointed attorneys. Before her attorney talked to her, there was a reason she had several court-appointed attorneys, and that's because nobody would follow through with the things that they needed to do. And so before they even talked to the client, they talked to the DCS attorney, they talked to the other attorneys, and all these attorneys are just blah, 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 gossiping about her case, violating all of her confidential information and her confidential communication with her attorneys, and basically just gossiping. They should never do that. And, I'll say I went through a period in law where, people would call me about a prior client, and, sometimes there were things I wanted to tell them, and maybe I just, some clients you get along with really well, some you don't, some you just have difficulty with. Some things, sometimes it seems to go smoothly and everything is going along. And there were times that with that very difficult client, you just wanted to say, oh my gosh, just be careful. Here's what happened. Here's what happened. And attorneys just should not do that. That is not their role, to gossip about their client and, to try to prejudice a new attorney against their client. And the same thing goes the other way. I would often pick up cases that had one or two or three attorneys. And I always know, I could tell from the attorneys that they had before what kind of experience they probably had. But, I was very careful. If I was going to talk to a previous attorney, I would ask the client first, can I talk to your last attorney about what happened in court? Or do you think they have any other information? If they said no, because they had a bad experience with that attorney, it was flat no. Like, you should have the client's permission first. The discovery is so important, and that goes along with being proactive. Attorneys have got to get discovery. I don't know what the problem is with making a discovery request, but they simply won't do it. And that includes collecting discovery from a guardian ad litem. Now, remember, a guardian ad litem participates in the case like a party, although they're not really a party. They're the child's attorney, and they're going to get up and they're going to ask questions. They may even call witnesses, and guardian ad litems should receive a discovery request as well, particularly for any experts that they may call, because I've had it happen where DCS can't get a good expert, or I oppose their expert because they didn't timely disclose it. And then the guardian ad litem goes, oh, well, then I'm going to use that expert because I wasn't asked about experts. So discovery requests should go to the guardian ad litem as well. And ask their position. Ask them what they believe the best interest is. Attorneys and grounds for complaint, a lot of times it's failure to communicate, incompetence, failure to provide copies of documents, failure to seek discovery, failure to prepare the case, conflicts of interest, secretly commuting with opposing counsel. I mean, those are the basics. That is the basics. So if you have an attorney who was maybe a prior attorney with the co-counsel. Oops, I need to mute out here.
Yeah, what?
So if you have an attorney, maybe they were prior, maybe shared an office with opposing counsel or something at some point, those are the kinds of things that should be disclosed. So what to expect? One more, what to file? Again, written complaints, online complaints, documents, witnesses, audios, basically the same thing for all three, is that you need to prepare the evidence to take to them so that essentially they can create probable cause to get the investigation initiated. The attorney is going to deny all claims and twist the truth, and you need to have that in hand, because a client can usually sit down and go, this is a lie, this is a lie, this is a lie. And they need to respond to those and point out what that is. Okay, so why do we need to document incompetence? This great little AI created image over here. I asked AI to create me an image of a child sitting in a courtroom with money all around her on the floor, and this is exactly what they did. I think this is an awesome image. I'm probably going to use it hundreds of times because it depicts so much. But why is it so important to document incompetence? Because we have to show it in the entire legal system. They fail children. The state legislators need proof of incompetence, and the laws need to change to hold participants accountable until we can really show, look, this is what happens in the courtroom, because legislators defer to the court process over and over and over and over again. They defer to judges over and over and over again. So that's why we have to document what is actually happening, and not just the case itself, not just, look, there was no abuse, they didn't provide services, etc., but how the entire case is being handled. So judges and attorneys, during the disciplinary process, sometimes the boards do not even get a response, but summarily dismiss the claim. If you get a response, they'll lie even more. So respond and save the communication. So a lot of what I have found over the past few years is that, especially judges, and perhaps because I filed a couple of judicial complaints and the judges wrote ridiculous responses that were not even true, that what I have found the board will do is shut down the complaint and go, oh, there's not enough substance here to even open investigation. And so they will not even let the judge respond, because they know these judges are going to respond with saying something really stupid. And it's the same thing with some attorneys, or they'll turn it over to what they call CAP, which is their where they have disputes over fees, right? I had the attorney disciplinary board turn a complaint against a DCS attorney into a CAP for a mom. And it's like, this is not about a fee dispute at all. This is about them violating ethical rules. Caseworkers. So we haven't really included them here, honestly, because there is yet to be an effective method of a state agency caseworker complaint program. The agencies, most of the agencies have what they call a customer service contact email, typically on the website. Some agencies have an ombudsman, which they're trying to hide the ombudsman all the time. I don't know. I think that's just, they just want to give somebody some extra money. So they give somebody that job and pay them $100,000 a year, but they do little to nothing. And most agencies have a contact for an upper level case management supervisor, etc. And most caseworkers have the name of the supervisor on their voice message, or you can ask for the name, phone number, and email of their direct supervisor, and then you can go up the chain, so to speak. So very, very frustrating to go up the chain. But with caseworkers, if you file directly with the central office, they're going to say, well, you need to tell their supervisor, and then there's a regional supervisor. So there's about 5 layers of supervision before it actually gets to the main headquarters. However, again, we've got to collect that information. We've got to show, again, this repeated complaint I'm getting about caseworkers is parents are doing what they were told to do, and they're giving it to the caseworker, and the caseworker is not turning it in. They're not putting into the case plan that it's been completed. They're cutting parents off. They're not even letting parents get it into the court file. It's way out of control. This is the worst I've ever seen this with some of the cases that have contacted me recently. All right, so moving past the individual complaints. So beyond complaining on the conduct of individuals in the case, claims can be brought for civil rights violations, claims commissions, and fraud, waste, and abuse as general claims against the system. So for federal complaints, there are two different types of complaints. Basically, through HHS, there is an Office of Civil Rights. So remember, all foster care comes under HHS. There's a subdivision called ACF, Administration of Children and Families, but it is an HHS office. So the Federal Office of Health and Human Services will take complaints on civil rights violations, but honestly, typically, they are sort of glossing over anything unless it includes discrimination or disability violations. You can get a little bit of a response. Typically, I've had a disability violation response, provided them tons of information. Ultimately, keeping the same person employed in a federal office to review these is extremely difficult. But, getting these complaints prepared and filed, we have to just really make that an ongoing effort. So fraud, waste, and abuse of federal programs, federal programs is one part, and then using postal, email, and otherwise to devise a scheme to commit fraud. We're going to talk about that in the next slide. So why complaints are important, bringing the conduct to the attention of a third party. Always, always, always. So this is, if you Google civil rights, Health and Human Services civil rights complaints, it will get you to a page that looks like this. And you will see, I think it's on this, filing a civil rights complaint right there in the middle of the page. So you can click on that. It will take you to a form, and you can also upload documents. Again, it's going to ask for information such as names, addresses, witnesses, etc. So I highly advise that before you file a complaint on a form, that you sit down and you type it up either on a Google Doc or a Word doc or something, and you have all the details, right? You have all of everybody's name, address, phone number, and then, start itemizing what the complaints are with dates, etc. But type that up on some document that you can either copy and paste into a form or that you can print and read off of, so that you have that in front of you. If you use a form, unfortunately, once you hit submit, all that information is gone from you, and it's very tiring and frustrating to have to sit down and pull up all your information over and over and over. Now, the other place where you can report fraud, waste, and abuse is the GAO, or the Office of Government Accountability. And, we haven't used this enough, but you'll see right here in the blue, there is a link to report and prevent fraud. If you start investigating fraud and abuse complaints, you'll see there's tons of complaints on Medicare fraud, Medicaid fraud, opiate, pain clinics, etc. And we really have the same thing going on with foster care. So, we should be doing it to report fraud and abuse of foster care. If a child is in foster care a day longer than they need to be, that's fraud, waste, and abuse. If a child is being adopted and they could have done a parent restoration, that's fraud, waste, and abuse. So we need to be reporting every time that comes up. And that, as advocates, as an advocacy group, that's something we need to work on. And I don't know, we need maybe a little fraud, waste, and abuse, session, right, where we all get our computers and start filing them or looking at how to do that. We might make that a special sort of a team session. All right, so under federal laws, under Title 18 of the United States Code is the criminal code under federal law. 18 USC section 666, very interesting number, I think, 666, is to report fraud of government funds, and 18 USC 1341 is the interstate postal electronic fraud and schemes. So down below 666 says whoever embezzles, steals, obtains by fraud, knowingly converts to the use of any person, misapplies property that is valued of 5,000 or more and is owned by or under the control of the government, or corruptly solicits for the benefit of anyone anything of value intending to be influenced or rewarded by any business transaction shall be fined, blah, blah, blah. And it goes on and on. So basically, this is saying if there's an application or a request for funds that are not properly applied for, it is a violation of USC 666. Who did I see clapping down there? Okay. Under 18 USC 1341. Oh, thank you. I see somebody signing for us. Okay. Whoever devised or intending to devise a scheme or artifice to defraud for obtaining money or property by any means, by false or fraudulent pretenses, representations, promises, to sell, dispose of, loan, exchange, alter, give away, distribute, supply, furnish, or procure for an unlawful use any counterfeit or spurious coin, obligation, security, or other article, or anything represented to or intimated or held out to be such counterfeit or spurious article for the purpose of executing such scheme or artifice or attempting to do so, or places any postal office or authorized depository, and that statute goes on and on too. But basically, this code, 18 USC 1341, is the code that was used in the state of Illinois for the fake foster care fraud scheme. Okay, so this can include using deposit, using email, using the postal service for committing the fraud. And this is what they use. I was surprised it didn't have the other one, 18 USC 666. Maybe they'll add that later. But that charge was brought under 1341.
Connie, Isaac is hand signaling. It would be great to have him to do that on the side. Just
Yeah, I
saying.
know. Let me see.
That's awesome.
I know.
For the
And you know what?
handicap, that's to our advantage there, Isaac.
I
Perfect.
totally agree.
Aw.
I wish I were that technically savvy. I'll have to work on that.
Aw. Good
Uh,
job, Isaac.
yeah. So show using oops, there we are. Ah, there I see. But I can't do it and show the screen at the same time, unfortunately. Now I've got this. Okay. All right, I'll work on technically how to do that. I think what I would have to do is put up just two images, Isaac and myself, if I can figure out a way to do that, and then put us on the side. But I really appreciate it, Isaac.
You're welcome.
Thank you. And I am quite okay if you ever, if you want to do when these videos are put up in YouTube, and if you have a way that you can record a Zoom, which is you and the YouTube video, you can sign the whole thing. You are quite welcome to do that at any time. All right, let me get back here to where I was. All right, civil rights claims and claims commissions. So these are two totally separate things. So under the civil rights, everybody is always saying, I want to sue them, I want to sue them, I want to sue them. It's a huge, huge challenge for so many ways. Here is what the law says. It sounds so simple and it's been so bastardized. But basically, the law says every person who is under color of any statute, ordinance, regulation, custom, or usage of any state or territory of the District of Columbia subjects or causes to be subjected any citizen of the United States or other person within the jurisdiction thereof to the deprivation of any rights, privileges, immunities secured by the Constitution and laws shall be liable to the party injured in an action at law. That sounds so, so simple. Color of law basically means somebody who's employed by the government. A person is a U.S. citizen and rights and privileges and immunities guaranteed by the Constitution or by federal or state law. Now, this is right here, the first little trick, because 42 USC, and that should be 1943. Oh, you can tell I did this quickly this week. Does not cover state constitutional provisions. So if your state constitution has a stronger provision than the U.S. Constitution, it will not provide you protection under this code. So I'm going to make myself a note. I'm going to make a correction to the slide. So, and there's, of course, so many obstacles to civil rights claims. You have to specifically say who did what. You have to show that it is a constitutional violation. You have to show that it was clearly established. You have no idea how hard that is. It is so difficult because there are so many loopholes. The State Claims Commission is a bit different. So the State Claims Commission has jurisdiction over the following types of claims: alleged negligence by state officials or agencies, such as negligent care, custody, control of persons, personal property, animals, professional malpractice, negligent operation of vehicles, etc. Because under a civil rights action, you cannot sue the state. So you cannot sue the state for damages. And so because of the 11th Amendment and sovereign immunity. So you might, though, have a claims commission action. And I think I have that in the next slide here. So let me move ahead. We broke that down a little bit more. All right, so civil rights litigation. I still didn't get the code here right. Sorry, guys, I will correct these slides. 42 USC section 1983, not 43. I was probably thinking of something else yesterday. The Fourth Amendment is the unlawful search and seizure. The 14th Amendment is procedural and substantive due process, and you must identify the acts of the person. So for children, there is a Fourth Amendment protection against unlawful seizure. We don't see enough civil rights actions in this. If a child is unlawfully seized, I really wish there was a way we could bring more of those cases. Unfortunately, what we face is children are unlawfully seized and held forever, and so we never get a chance to bring those actions. They also have 14th Amendment rights for procedural and substantive due process rights. So the distinction, just the quick distinction, is procedural rights. Again, procedural due process is notice and the opportunity to be heard. Substantive due process is the family integrity. So there are two totally separate causes of action under the civil rights litigation. Parents' rights are typically under the 14th Amendment against procedural and substantive due process rights, and there can be a Fourth Amendment against malicious prosecution, but only if there is a criminal prosecution. It will not apply to civil prosecutions, unfortunately. And of course, the deep throat of civil rights is absolute immunity and qualified immunity. I can move this so you can see that. And qualified immunity, which protects all but the most ignorant. All right, so the State Claims Commission, talk about that just a little bit more. State cannot be sued under 42 U.S.C. 1983. I see I got it right here. Because of the 11th Amendment and sovereign immunity due to most state constitutions saying that you cannot sue the state and access the state treasury. However, most states do have insurance and they do have a claims commission. So here are some potential places where a state claims commission action could be brought. So first of all, there are claims against the state for injuries in foster care. Now, the problem is it would not apply to a private contractor. You would have to sue the private contractor or the private foster care company separately. Second are the claims against the state for failure to pay for foster care services. I have somebody right now who has filed a state claim. She took on a very disabled child. They told her that this was a level 1 foster care child. Then they refused to get him medical services. They refused to provide the day the daytime services for the child so that she could work because they had told her they would. And then they refused to provide medical care. So she filed with the Claims Commission, and she went back and she calculated what she should have been paid for foster care and then what she lost from work because she did not get those services, and then what she should have been paid for the extra babysitters that she had to pay out of pocket. The claims against the state for lack of proper medical services to the child in foster care. Unfortunately, the person who would need to bring this would either be a foster parent or could be the parent if the child is returned. The parents just simply cannot bring an action for a child that is in foster care. There's sort of this perhaps caveat that they could, but I've never seen anybody be successful at that. All right, then the claims against the states for damages arising out of state employee negligence. This is a tricky one. I've not seen anybody apply it to child welfare cases. But, is there a claim? There's this question about, is there a claim if the social worker is refusing to turn over your documents when you've completed everything and you've been told by the state your kids would come home if you completed those services? So that is a potential claim. Again, this is just a complaint I've heard coming up over and over and over again. All right, now this is not the same as government tort liability, which applies to county and municipal governments. All right, why are complaints important? All right, so this picture I thought was great because it's like a whole room full of people taking an oath. So bringing conduct to the attention of a third party is very, very important because this is not just about parental rights, it's about the process. Most of the players take an oath of office to uphold the Constitution and the rights of citizens, and we owe them the courtesy of reporting their conduct. We owe the profession the courtesy of reporting their conduct. The whole disciplinary process has been so misused in so many ways, and it's got to get down to the nitty-gritty of the people and the people's voices. I think that may be it. All right. Okay, y'all. So this is the conclusion of this training. I'm going to stop our record so we can have some chat. I have not checked to see if you have any specific. It's very difficult for me to look at the chat and see if you have questions along the way. I apologize for that. But we will talk about those when we go off record.